welcome. We're going to do legal interpreting. My name is Grace Donohue, and I'm here with
Jordyn Beal.
We're going to start with the history of legal interpreting. It started in 1964 with the workshop on interpreting for the deaf. Ball State College of Indiana created the Registry of Interpreters for the Deaf. In 1965, California State University of Northridge established the first interpreter training program. In 1966, the National Technical Institute for the Deaf forms another interpreter training program. In 1969, St. Paul Technical Vocational Institute and New York University forms a community for interpreting programs. In 1972, RID conducts the first certification examinations. In 1973, Title V of Section 504 of the Rehabilitation Act amendments provides access for deaf persons participating in programs or activities receiving federal financial assistance. In 1974, the National Interpreter Trainer Consortium is formed, which attempts at national programs for interpreter training. In 1975, the Education of All Handicapped Children Act requires all disabled children to be educated in the least restrictive environment, which begins the widespread mainstreaming of deaf children. In 1977, the Bilingual Hearing and Speech Impaired Court Interpreter Act requires federal courts must appoint and pay for interpreters for deaf persons in federal criminal and/or civil actions initiated by the government. Now, in 1978, the Court Interpreters Act defined the requirements for court interpreters. In 1990, the Americans with Disability Act, or ADA, expands the Section 504's powers to businesses with 15 or more employees that they must make reasonable accommodations, and the law says interpreters should interpret effectively, accurately, and impartially. Now, in 1960, the Individuals with Disability Act reaffirmed the least restrictive environment to sustain needs for interpreters in mainstream classrooms. Now, in 1998, the Telecommunications Assembly Enhancement Act, or TAEA, the federal government must provide relay calls to, from, and within itself. Now, there is an ongoing Title IV of the Americans with Disability Act that does not mandate but regulates and allows for reimbursement of video relay services, because the FCC reports that VRS calls average 2 million minutes per month. I believe it was started in 2006 and is now still ongoing. The qualifications. Now, the Americans with Disability Act of 1990 requires the use of qualified interpreters. Now, qualified interpreters are ones who are able to interpret effectively, accurately, impartially, but both receptively and expressively, using any necessary specialized vocabulary. The NADRID Code of Professional Conduct requires interpreters to possess the professional skills and knowledge required for specific interpreting situations. Now, the certifications. RID awards the Specialist Certificate, which is legal, or SCL, to interpreters who meet specific criteria regarding prior certification, education, and experience, or the CDI, which is Certified Deaf Interpreter. Since there are a lack of legal interpreters, the responsibility falls to interpreters with a generalist practitioners to interpret in the language used by the deaf person and who have successfully completed the legal interpreter training in order to understand and use the necessary specialized vocabulary associated with legal settings.
Next, we have legal settings, which consist of attorney-client appointments, police interactions, and courtroom proceedings. With attorney-client appointments, this can occur in legal aid clinics, the office of an attorney, hallway of the courthouse, or a conference room at the city or county jail. For police interactions, this usually occurs in the police department, the city or county jail, a person's home or business, and the relationships are usually between the police and victim, police and suspect, and the police and the witness. For courtroom proceedings, usually it deals with civil, criminal, and administrative hearings. It consists of either an adult or juvenile, And the deaf person's involvement can usually mean that they are the plaintiff or defendant, victim or witness, member of the jury, family member, the deaf attorney, or deaf judge. This is rare because most deaf attorneys and deaf judges have their own personal interpreter. Next, we have standard practices in general. After accepting an assignment, the interpreter or interpreters must conduct an analysis based on communication needs in respect to the factors that impact communication. A few of the factors that impact communication are the numbers of interpreters required, positioning of the interpreters, and turn taking. When staffing a legal matter, there is usually a minimum of 2 interpreters. This is because they can provide relief for one another, since court proceedings are usually a very lengthy process. Also, while one is signing, the inactive interpreter will be able to monitor the active interpreter for an accurate interpretation. And because the deaf community is diverse, this means that there must be a variety of interpreters on hand. Meaning, if your deaf client uses ASL, you must be able to interpret into ASL. Or sign English or native ASL for a person who hasn't been exposed to sign English or ASL as much. And if you are a native signer of ASL, you are usually deaf and you have been awarded a certificate from RID called the CDI. There are a few risks in interpreting in legal settings. If you, as an interpreter, are called to the witness stand, this usually means that you have to defend your work. And as a safety net for this, they offer video recording services, opportunities for consecutive interpreting, and also a deaf interpreter. Next, we have placement, protocol, preparation, and payment. As far as placement, you are usually placed slightly behind or beside the hearing speaker, and this is because it is often rapid turn taking place between the hearing speakers. You cannot sit or stand in certain areas. For example, the well, which is the area located in front of the judge's stand, is off limits, which is usually an ideal place because it does allow an open space for you to be seen by your deaf client. As an interpreter in legal settings, you must be highly skilled. Because you are going to be placed in many different areas, you must own the vocabulary and legal terminology. For example, your book, So You Want to Be an Interpreter, provides an example of a legal interpreter having to interpret for a client who is being held in a jail cell. You are not allowed in that jail cell. You will have to interpret outside of the cell, which provides a barrier between you guys, and that will be the actual door to the wall. So you will have those iron bars in front of you, which is hard to interpret from. So you must be highly skilled. Also, you must be able to effectively express your needs and predict them as well. In terms of payment, most interpreters set their own fees. But in some courts, the court system will set their fees for their interpreters. And that is going to be all for me and Grace, and we hope you enjoyed our project.